Hi, good morning. This is Victor Manibo, one of the attorneys at Wang Law Office, and you're again joining us for the AM Show. This is our new show on YouTube where we answer your questions about common immigration topics.
Yeah. Hi, I'm the host Ariel. Also, I'm a senior paralegal in Wang Law Office. Our show going to start every Friday at 8 a.m. EST. You are free to write us anything, any question.
Yes, so like I said, we try to help you out with some of the common questions that you have about certain immigration topics. In the past few weeks, we've been talking about family-based petitions and getting a green card through your family members. Today, we're going to continue on that kind of topic.
Yeah. Victor, can you introduce a bit on your own background?
Sure. Before we get started on the questions, I just want everyone to know, in case this is your first time joining us, that I am an attorney at Wang Law Office. We specialize in immigration, and I've been working for this firm for 10 years now. It's a long time. And also, I've been an attorney for 12 years. Most of the work that I do is in immigration court, but I also do work in criminal court sometimes, especially when it impacts someone's immigration status, which is kind of appropriate because that's the topic that we're going to talk about today.
Yeah. I want to ask, if I have a criminal case, whether it's going to affect the family-based green card?
Right. So this is one of the common questions that we get from people who want to hire us or people who are already clients. Like, how does a criminal case impact my green card? Specifically, something that was a green card application that is based on a family petition. Well, there is no short answer to that. It's very complicated. Obviously, a criminal case complicates your eligibility for a green card. Sometimes you might have to explain your criminal history, and sometimes if you have a criminal history, it might mean that you're not going to be approved for a green card. So the short answer is yes. If you have a criminal history, it could affect your green card, but it depends. It doesn't affect it all the time. And we're going to get into all the details of that.
Yeah. Do I have to inform USCIS about my criminal case?
So the first answer is yes, but as with all the answers that I have in this show, it's always yes, but it depends, because in general, when you're applying for a green card, you want to answer all the questions and complete the form, right? And one of the questions in the I-485, which is the green card application, is about your criminal history. It asks for all of your arrests, charges, convictions in the US or outside of the US. Now, those are a lot of terms, and we can go into that in a little bit. But basically, the purpose of that question on the form is to see what kind of criminal history you have. And, Ariel, you were asking, do I have to inform USCIS? And the answer is yes, you have to inform them, because they're asking it and you have to provide it. You can't leave blanks on your form generally. And you have to inform them because they will do a background check on you anyway. Every person who goes through the green card process, like we talked about last time, goes through biometrics where they get your fingerprints. And when they do that, they're checking for your criminal history also from all the databases all over the country.
You mentioned earlier there is different kind of criminal case, right? Which kind of them I have to inform USCIS?
Right. So like I mentioned earlier, every case is different, and there are lots of types of crimes that might disqualify you or might complicate your green card application. In general, you have to just mention all the arrests that you have. So if you've been arrested by the cops, put in handcuffs, brought to jail, that kind of thing. Every time you've been sent to criminal court, that's usually a criminal case if you've been sent to criminal court. Sometimes you might not have been put in handcuffs, or you might not have been sent to jail, but you might still have a criminal case if, let's say here in New York, you've been given what's called a desk appearance ticket, or just some sort of ticket. The differences between these types of things is something that an experienced immigration attorney and criminal attorney can help you out with. So just bear in mind that not all crimes are, involve being in prison or being put in handcuffs. Sometimes they're just tickets. So you have to list all of those. And then also, sometimes a criminal case gets dropped or dismissed. Maybe, you were wrongfully accused, or the police made a mistake, because they sometimes make mistakes. Even if the court says, okay, this case is dismissed, this is gone, you still have to declare that with USCIS.
Is there other kind of criminal case I don't need to mention the USCIS?
Right, so again, this is kind of complicated, and it's hard to summarize with a short answer. But for example, like I was saying earlier, sometimes criminal charges are dismissed or dropped, depending on the state that you're in, or depending on what kind of case it was. You might still have to put that on the form. Sometimes you don't have to, especially if it's a case that's been dismissed and sealed. You might not have to do that, depending on the jurisdiction you're in. Also, you don't have to inform USCIS of every traffic ticket, because those aren't crimes. Those are more like violations. Like, for example, if you get a speeding ticket, USCIS isn't generally interested in that. But the thing is, it differs depending on what state you're in, or depending on who is the police or the authority that issued the ticket. Because some tickets that a traffic cop issues might be considered a crime. Like, for example, you get a ticket for speeding, that's just a violation. But if you get a ticket for drunk driving, that could be considered a crime, which is a little bit more serious, and which impacts your green card application. So again, like, all of these things differ. And if you have any of these experiences, getting a ticket or getting arrested or getting sent to jail, you have to tell an experienced attorney, preferably someone who specializes in immigration, criminal law, like my law office, so that we can tell you, okay, this is something that you need to tell USCIS, or like, this is something that USCIS doesn't require that you declare.
So is there any consequence if I fail to inform USCIS about my criminal history?
Yes. Oh, the question to this is always yes. Like, if you lie on your application, and it's not just lying, like, you make something up. It's also lying by omission. If you don't say something that if you don't declare something that USCIS requires, that's only gonna hurt your application, because, like I said, when you apply for a green card, they will ask you to do fingerprints, and then they will run your fingerprints and your biographical information through their databases to see if you have any sort of criminal history. And if you do, and they find out that you do, and then you didn't put that in the form, that's going to be a problem.
How did USCIS going to find out during this green card application?
Well, so when they take your fingerprints, and usually that's at the beginning of the process, right? You submit your I-485 application with the supporting documents. After a few weeks, you get an appointment to do your biometrics, which is where they take your photo and they do your fingerprints. And so once they get your fingerprints, they do a criminal screening, which involves having your background, your fingerprints run through their databases, which is connected to all the law enforcement agencies around the country, because USCIS is a federal agency, so they have that information. So they will find out if you've been fingerprinted for a crime, and for most crimes, if you get arrested, you get fingerprinted. That's like standard, right? So that's how they find out.
Okay, so if all criminal case is going to have a negative impact on the green card application?
No, not all kinds of criminal cases will impact your green card application, but most of them do. And this is going back to what I was saying earlier about how some criminal cases you have to declare to USCIS, and some you don't. A criminal case that's been dismissed and sealed, you don't have to, depending on the jurisdiction that you're in, because sealed means like it's as if the case never happened, or like it's very confidential. It shouldn't impact your immigration status or your immigration applications. But that's language. Dismissed and sealed is language that's applicable, for example, here in New York where we practice, and in some other states. In other states, it might have different terminologies. So again, you need to consult with an experienced immigration attorney to see whether or not something will have a negative impact. Generally, a criminal case will have a negative impact, but a few of them don't.
So is there different type of case? I heard the word, maybe some case relate to job, maybe some case relate to the felony going to affect the green card, right?
Right. So you mentioned the word felony. One thing that our viewers need to understand is certain terms. Like a felony is a criminal case where the sentence is 1 year or more. Generally, if you have a criminal case like that and you've been convicted, meaning a court found you guilty or you pleaded guilty to a felony, that might negatively impact your green card application, because some kinds of felonies are called aggravated felonies. And an aggravated felony makes you inadmissible, and which means like you can't be let into the US or you can't be given a green card. Now, what an aggravated felony is defined in our immigration law. They have a long list of felonies. And we can go into that later on in more detail, but that's just one thing to remember. Like, when you hear that, I have a felony history. You should think, this is probably going to make me disqualify me for a green card. I should tell my lawyer about this. And you also mentioned drugs. Like any case that involves drugs, the immigration system that we have is very strict on drugs. So it doesn't matter if you only got a ticket, or it doesn't matter if you didn't go to jail, you only paid a fine. And in some cases, even if the conviction was overturned, as long as it's a drug case, USCIS wants to know about that because it can potentially disqualify you. So that's another one of those types of cases. Drug convictions usually will make you inadmissible and ineligible for a green card.
So if there is a misdemeanor criminal case, is that going to affect my green card application?
And now you mentioned another term that I think our readers need to know about. Yeah, misdemeanor. Misdemeanor is a type of crime where typically the sentence is less than 1 year. So 364 days in prison or in jail, that's a misdemeanor. Like 365 over 1 year, 1 year or more, that's a felony. Both of those are crimes, and the only difference, at least in a lot of states, in a lot of jurisdictions, the only difference is the length of the sentence that the person spends in prison. So a misdemeanor, because it's like got a shorter sentence, right? Like less than a year, they are more minor crimes. However, that doesn't mean that it doesn't impact your green card application like a felony or like an aggravated felony. It still does, but it depends on what kind of misdemeanor it is.
So what kind of case belong a misdemeanor?
Depends on what state you're in, and that depends on whether or not like you actually get convicted. If you don't get convicted for a misdemeanor or a felony, it's not gonna hurt your chances for a green card. But if you do get convicted, then you will probably suffer some consequences. It's a misdemeanor, and the next question you have to ask is whether or not it's a crime involving moral turpitude. And that's a new term that, like, I'm just going to tell you a lot of new terms today. But that's another term that you have to be aware of, because some misdemeanors will affect your green card and some will not. But if it's the kind of misdemeanor that is called a CIMT, or a crime involving moral turpitude, then it might disqualify you for a green card. And we can talk more about that. What is moral turpitude, right? Moral turpitude means it's a crime involving moral turpitude. Usually involves some sort of fraud, or it involves violence, hurting people or destroying property. Fraud means you're fooling someone or deceiving someone to get something out of them, like you're trying to get their money in a deceptive way, or trying to get their property in a deceptive way, or doing trademark counterfeiting, fake handbags, or counterfeit money, for example. That's fraudulent. So fraud and violence and other crimes that involve moral depravity, meaning it's really, really evil. Like obviously sexual assault is a horrible thing. Any crime that involves hurting children or the elderly qualifies as a CIMT because it involves moral depravity. It's something that we as a society really disapprove of. So if your crime involves those sorts of things like fraud, violence, moral depravity, it's going to be a CIMT, and it might disqualify you from getting a green card.
So does a misdemeanor conviction in one state going to result in other kind of case under the immigration law?
So this goes into the question of jurisdiction. Like, for example, you get convicted for a misdemeanor or even a felony in another state, and now you live in another state, and now you're applying for a green card. Like, does the out-of-state conviction affect your green card application? And the answer is yes, because our immigration system is a federal system, which means it's run by the U.S. government, and it looks at your criminal history like as a whole. It even asks, our immigration system even asks for your criminal history outside of the country. So yes, out-of-state convictions and even out-of-the-country convictions is something that USCIS is interested in knowing about, and it's something that can affect your green card eligibility depending on how serious the crime is. If it's an aggravated felony, if it's a drug conviction, if it's a CIMT, it doesn't matter where it is, if it's out of state or in the state that you live in, and sometimes even if it's out of the country.
So you mentioned the word aggravated felony. So it's going to affect my green card. How is it going to affect my green card application?
So aggravated felony, again, is a term that's defined in our immigration laws, and those are a list of crimes that the government, that our leaders have thought are very serious. So we're not going to give green cards to people who have been convicted of these crimes. It's a long list, or you can check 8 USC 1101 843.
Can you give me some sample of this?
But yeah, the examples are obviously murder, rape, kidnapping, anything involving crimes of violence, crimes using weapons. One common one that I see with our clients is fraud. If you defraud other people, and the amount of the fraud involves something that's $10,000 or higher, that's an aggravated felony. If you defraud the government, for example, if you do some tax evasion, you don't pay your taxes, or you lie on your income tax returns, which is relevant now because it's tax season. If the amount of the fraud is $10,000 or higher, that's also an aggravated felony. So these aren't usually serious crimes that that you think about when you see, oh wow, that's really serious. If you commit arson, if you burn down a house, that's an aggravated felony. The long list is in our immigration laws. If you're not sure, obviously consult with an immigration attorney who also specializes in criminal law.
Yeah, so I know that if I have a criminal case related to maybe say marijuana, is that going to affect the green card application?
So we mentioned earlier a little bit about drug convictions, and you're asking about marijuana, which is in an interesting place right now because a lot of states are legalizing or decriminalizing marijuana offenses. And so it's different, for example, how marijuana is treated in California and how it's treated in New York, and how it's been treated in the past, and how it's treated now. Now, I mentioned earlier, our immigration system is a federal system, and the federal system has some criminal laws. And even though other states have different laws that decriminalize or legalize marijuana, under the federal system, marijuana is still a controlled substance or a drug that is criminalized. So it's still a crime to sell marijuana, for example, under the federal system, even though in some parts of the country it's already legal. So the question is, how does this impact my green card application? So there is a little bit of an exception for marijuana convictions that involve 30 grams or less of marijuana. So for example, if you were found in possession of like less than 30 grams of marijuana, you might be able to get your green card with no problems. Obviously, you still have to tell USCIS about it, but it's not going to disqualify you. Other than that, anything that like involves any kind of drug, including marijuana, is going to disqualify you from getting a green card.
So you mean that as long as the case is related to a drug conviction, then no green card, right?
Yes, unfortunately, that's how strict our immigration system is when it comes to drug offenses. Again, the only exception is, one conviction for like something that involves 30 grams or less of marijuana, then you'll be okay.
So is there anything we can do to get the green card, maybe a waiver or anything?
So let's say you have a criminal conviction, right? And you mentioned waiver because we talked about waivers before a little bit. Like sometimes you have a problem in your green card application and you might be able to get a waiver or ask the government, USCIS, for forgiveness. Like, hey, I know this thing happened in my past. Maybe we can waive it. And for criminal convictions, there is a waiver available. It's called the I-601, but it only applies to certain kinds of crimes. It's not available to waive all sorts of crimes. Like, for example, if you have a murder conviction, you can't ask USCIS to just like look away from that and say like, okay, fine, we'll waive it. Okay. You can get a waiver and USCIS might approve it for crimes that are CIMTs and for drug possession convictions of marijuana 30 grams or less, you can waive that. The I-601 is a separate application form from the I-485. Sometimes you might need to file it together with your I-485. Sometimes it's advisable to do that. Sometimes you don't have to. But the short answer is for CIMTs and that very narrow exception on marijuana possession, yes, you can get a waiver. Other than that, you can't waive a conviction.
So is there any requirement on this I-601 waiver?
So for the I-601 waiver, it's a hardship waiver, meaning you have to show hardship to certain family members if your green card is not approved. You basically have to get USCIS's sympathy in saying like, hey, I did this wrong thing a long time ago. I have this one misdemeanor conviction. It's a CIMT, and but please forgive me because if you don't give me a green card, my family members will suffer. So that's basically the point of the I-601. And if USCIS is convinced, they're going to approve it and they're going to waive your criminal conviction. But you have to prove hardship to certain family members, specifically a U.S. citizen or a lawful permanent resident parent or spouse. So those are the relatives that you have to look at. And unfortunately, children are not counted here. So if you have a U.S. citizen parent or U.S. citizen spouse or an LPR parent or an LPR spouse who will suffer hardship if you don't get a green card or if you're deported from the U.S., then you might be granted an I-601 waiver.
So if I involved in a criminal case, is there a reason for me have to hire an immigration lawyer for my criminal case?
So let's say, let's break that question down, right? Let's talk about first for people who have not made their I-485 applications yet, or like they haven't filed it yet. Like, they're thinking of filing it. or they haven't even begun the process yet, but they know they want to, right?
Mhm.
And then unfortunately, let's say they get arrested for an assault. They get into a fight with their neighbor. Should they hire, and then they get sent to court. If they get arrested, they get to criminal court. Should they hire an immigration lawyer? Well, first, what you need for criminal court is someone who specializes in criminal law. But because you are thinking about your immigration status, maybe you don't have immigration status, or you're worried about your immigration status in the future, it's more advisable to get a criminal lawyer who also knows how criminal cases impact your immigration status. So someone who specializes in both criminal law and immigration is ideal.
Just like us.
Like our lawyers here in my law office, like I deal with these kinds of cases all the time. Our lawyers deal with these cases all the time. Now, and that's important because how that criminal case ends will determine whether or not it impacts your future I-485 application. So that's the short answer to that. Now, if you are, for example, you already approved for a green card, you already got your I-485, it's already approved, yeah. And then you get arrested for same thing, assaulting your neighbor. Should you hire an immigration lawyer? The answer is also still yes, because even though we've been talking for this entire time about people who are about to apply for a green card, for people who already have their green card, sometimes that green card can be taken away if you're convicted of a very specific serious crime. If you're convicted of an aggravated felony, that green card can be taken away. So it's still important, even after you get your green card, to find an immigration attorney and a criminal attorney in one, someone who specializes in both, to protect you from the criminal case so that you don't go to jail, and to protect you from getting taken away. Exactly.
So yeah, our time is up and then time flies. So feel free to leave your question to us.
Yeah, and this is a very complicated topic. Again, there are so many jurisdictions. Every state is different when it comes to their criminal laws. They have different rules, and our federal system also has very complicated rules when it comes to the criminal consequences, the immigration consequences of a criminal conviction. So it's always advisable to, number one, find an experienced attorney who specializes in both immigration and criminal law. Number two, be completely honest with that lawyer and be, follow that lawyer's advice. And finally, before we go, I know that I've been talking and answering questions, but like everything I say here, it doesn't constitute legal advice and it doesn't create an attorney-client relationship. But if you find yourself in trouble with the law and you've been arrested and you're worried about your criminal or your immigration status, please feel free to call us at Wang Law Office. We would love to hear how we can help you.
Yeah, please continue to follow us on YouTube. And thank you. See you next time.
Bye.